What I need to explain first is what we call the honour and dishonour basis of the law. Anybody studied this before? A couple of people in the room? Rowan, I know you have. So, to be dishonourable, how you behave to be dishonourable is the two main ways are through silence, and the other one is through argument, or to argue. Your silence is consent. It's law. Okay? So if you're pulled over and a police officer makes certain statements to you and you remain silent, okay, you're consenting actually to what's being said and you've contracted. And if you argue, you're also dishonourable. So isn't it interesting that if a policeman ever, or police woman, either way, arrests you, what do they say? You have the right to remain silent. Anything you do say can and will be held against you in a court of law. So if you're silent, you consent, and if you do want to say something, you're arguing, and it's admissible. They got you both ways, haven't they? The two ways to remain honourable are full acceptance. Yes, I was speeding, and here's the trump card, which is known as conditional acceptance. So if you fully accept the offer or the allegation, you're honourable. But you can also conditionally accept. I conditionally accept to pay the presentment that you've left on my windshield wiper for leaving my horseless chariot in the street somewhere too long, upon proof of claim that you have the right to do that. And we've got all sorts of letters written, a lot more detailed than that. So you are remaining honourable because you're conditionally accepting the offer that they've made to you. You can see a few confused faces. Silence is your consent and your acquiescence. Now, in law, it's 72 hours. So when they send you a statement or what we call a presentment, and you don't respond within 72 hours, you've contracted and you're in agreement. Isn't it interesting that whenever they send statements out, they say, please pay 7 days or 10 days or 14 days. As soon as you don't respond within 72 hours, then you've agreed and you've consented. Okay? You can reset the button on that by apologising. Can't you, Rowan?
Absolutely.
Yes. The Bible says you can be forgiven 7 times, 70 times, which is a lot. So you simply write and you say, I apologise humbly for my dishonour, and that pushes the reset button and you can start again. And people aren't aware of all this. There's people we know that go to court and every second sentence is, I humbly apologise and I seek the court's forgiveness. And they have to do it. It's interesting. Okay, so what we've done using the laws of estoppel and silence is we send time-sensitive documents. We notice them that they're time-sensitive documents, okay, and we respond to their presentments. And we do that through what we call a 4-step private administration process. Does the Bible not say go to your neighbour and try and settle? Not to argue, to go to your neighbour and try and settle. And so that's what you do. So this 4-step process is bits and pieces of quite a few processes that I've been studying over the last couple of years. And there is one process that Mark Patelik has been using called accepted for value and returned for value. And what they simply do then is they capture the document, they print across exactly that. We accept for value and return for value and authorise you to take the funds from my exemption account. Because I told you your birth certificate has been mortgaged and there's a what they call a set-off or an exemption account. You're authorising them with your birth certificate number, your tax file number and your Centrelink number to authorise them to take the funds out and clear the debt. He does ask for a proof of claim, and for me, I always sit with intuition and work out what feels right to me, and so I've put together a process that I have used where I don't feel they have the right to take the money again when you understand how they created it in the first place without a valid proof of claim. So the process that we use is a proof of claim. If I make a claim, do I have to be able to prove it if I go to court? Or can I go around making claims willy-nilly?
Prove it.
I've got to prove it, don't I? So that's all we ask them to do. So the first step of the process is we send them, if anybody's been in a legal battle before and somebody's making a claim against you, your lawyer will send a letter of request for further and better particulars so you know exactly what you're dealing with. And we do exactly the same. We send a letter of request for further and better particulars, and we accompany that with a hold harmless indemnity agreement. I'll get onto that in a second. So the letter of request is written in very legal format. We notice them that we are the principal, and we say things like, despite you addressing your statements and correspondence to some banking-created entity, juristic person, I, whoever you are, the living man, woman, wish to advise that I do not consent to being the surety, grantor, accommodation party for your bank or legal created fiction. Okay, and as indicated in the attached hold harmless indemnity agreement. So the hold harmless indemnity agreement notices then that you now have knowledge that a corporate you has been established, and you know you hold yourself not liable for anything that did without knowledge. It's an unrevealed, unconscionable contract. So that's this document here, okay, which we authorise for you. Please do not construe this notice as my refusal to lawfully pay any lawful alleged debt. Okay. I conditionally accept your offer for me to pay an alleged debt upon proof of claim to the validity of same as set out in this notice. So you're supplying them here a demand notice. You're requesting this information. And some of the things that you'll ask for is a validation of the alleged debt in actual accounting. You show us where the money came from. Did it come from bank deposits? Show us in accounting where it came from. They must be transparent with this information. Verification of your claim against me, a sworn affidavit and hand-signed invoice in accordance with the Bills of Exchange Act. I'll explain a little bit more about that as we go through. A copy of the contract signed by both parties and therefore binding both parties. If they want to come to court, don't they need prima facie evidence? Don't they need evidence of a contract? Does anybody remember signing a contract for a credit card?
Yeah.
No? You do? Yeah. I'd love to see it. I'll give you $10,000 if you can show me a contract signed by the other party.
I'll give you $1 million if you've got a contract.
I'd give you, yeah.
No, I signed it.
Yeah, exactly, which is not a contract. You've made an offer. Sorry, they've made an offer to you. You've signed it. They've not even signed it on the other side. You will not find a contract signed by both parties. They have to be able to come to court under the Bills of Exchange Act with wet signature contracts. Now, anything that they've had, they've probably traded off on the derivatives market anyway. Never have we had anybody turn up to court with a copy of a contract. So we asked them a few other questions, and they've never answered them. We've done somewhere between 180 and 200 matters now. We've never, ever, ever had a response to those questions. So then we let them know that we hereby give them 10 days' notice to reply to this notice from the date with a notice sent using recorded post. All of our clients send things using registered mail, where the other side have to sign for it and you get a copy back acknowledging that they've received it. They're addressed to the CEO and to the head of collections. Okay? They're actually addressed to a being inside the institution. So we require that back from them and signed under your full commercial liability and penalties of perjury, assuring and promising me that all replies and details are true and correct and without deception, fraud or mischief. Your said failure to provide the aforementioned said document as requested within the 10 days from the date above to validate the alleged debt will constitute your agreement to the following terms. So when they don't respond within 72 hours, even though we give them 10 days, when they don't respond, we then let them know that these are now the terms of the agreement. And under the 72-hour rule, you will now have what's called a tacit agreement in place because they haven't responded. They've been silent, so they're consenting to what you're writing in here. One, that the alleged debt did not exist in the first place, or that the alleged debt has already been paid in full, and or three, any damages I suffer, you will be held culpable. Then there's a whole list of other things that we write that will, if we list it on a credit reference association, we'll be sending them in injury monies for not limited to $10,000 per account. That if they should they pursue this matter without proof of a valid claim, you and your firm, we note the CEO's name, will be liable for the amount equivalent to your unsubstantiated claim and triple damages. Okay, so we write a whole series of new claims out in response, and the last one is we notice them what the process is. You will be issued with a notice of fault, a notice of default, and a certificate of dishonour accompanied by an affidavit in support. So we notice them that if they don't respond, that's the process that we're going to take with them. Very, very transparent. We then go on and ask a whole heap of other questions. We download recent documents from the RBA site, letting them know that we understand there's only 2.83% of currency available in notes and coins. We also make references to the Currency Act. which actually says that no more than $20 a day can be paid with using the laws of the Currency Act. So how do they expect us to clear the debt paying more than $20? We noticed them that if they come to our property, they're in breach of trespass laws, which the High Courts have ruled many, many times in the past, $187,000 fines. So we let them know of all that information. Okay. Out of, as I said, the 180 odd matters that we've sent, we've never had a response to any of those questions. We've had some letters back where they might say, we don't understand your template. Please don't use this template, it doesn't work. We'll see. Okay. So then after a period of 10 days, we then send them a notice of fault with an opportunity to cure. Okay, maybe they didn't get it, even though they've signed for it through the registered post. Perhaps they didn't get it. So we then send them a notice of fault saying that we sent a letter of request for further embedded particulars and a demand notice on such and such a date. Under the Bills of Exchange Act, the Evidence Act, the Crimes Act, the Criminal Code and Public Notaries Act, we will require you to respond. And if you don't, we give them another 10 days notice, then we'll issue you with a notice of default. Isn't that what the banks do to you when you don't pay the money? So all of these letters, just so you know, are signed by whoever's executing them and 2 witnesses, 2 good men, and the thumbprint goes in there to clearly demonstrate this is a live flesh and blood being executing these documents. Then we will go on and issue a notice of default with an opportunity to cure. Of course, we want them to be able to show up to be honourable, don't we? Because we're executing an honourable process here. So the notice of default and opportunity of cure is worded similarly to the notice of fault, letting them know that we wrote to them on a few occasions and we haven't heard back. We then issue the 4th step, which we do in the presence of a public notary, and I'll explain the importance of that in a second, on cotton paper, okay, which is of substance. All original deeds were printed on pigskin and cotton paper because it actually lasts 500 years plus. Okay, and the Bible says that documents ought to be written on cotton paper as well. So we do. Our clients write off to one of the only places we know of in Tasmania that supplies it. It's about $2 a sheet. It's not that easy to get through the printer, but we do. And we issue them with a certificate of dishonour, which lets them know that we've given them 3 opportunities to turn up to be honourable, and they've declined to do so. And through their silence, they're now in dishonour. And the document explains that quite clearly, that we wrote to them on this date, and so forth. If this is going to go to court, that's what the court system is based on. Yeah, absolutely. So again, that document is issued with your thumbprint. Again, it's with 2 good witnesses, and it's important that you have 2 witnesses. And then on this occasion, it's actually executed in the presence of a public notary. So on there will be his big red stamp that he presses down into the press, and he writes his information across it. And essentially what this does is takes the private process that you've executed and now makes it admissible in the public courts. Because you now have a public notary who's witnessing your execution of the certificate of dishonour, and not only the certificate of dishonour, the affidavit in support. I know we're getting into the technical stuff here, and people who are not technically minded might be all wishy-washy in the head with it. But if you're going to go to court or you want to follow the law, then you must do it excellently. So these letters have been very carefully drafted. You must be impeccable with the way where your names are in capital letters, the dates, certificates of mailing. Everything has a certificate of mailing, again with two witnesses, so there's a really strong paper trail, and that's super important if ever that has to go to court. It's also then issued with as I said here, an affidavit in support. Just so you know, in court, is hearsay admissible? No, the answer is no. So an affidavit is your first-hand personal knowledge of something happening. So the affidavit on your behalf is that you've written to these people, you've asked all of these questions, and to the best of your knowledge, you've had absolutely no response. And so you've executed this process. If they want to turn up to court, they must have an affidavit to rebut it, because an unrebutted affidavit will stand. And I believe that the use of the public notary and our affidavits and all the questions that we've asked has added weight to this process, because we've not had one client served. Out of 180 matters, we've had 2 clients listed, and I can tell you if those 180 matters had done nothing, they would have gone into default and been listed on CRAA or VADA or whatever it's called now. We've had 2 clients listed. One was with Citibank, and that was, I believe, a mistake on behalf of Citibank. We had one case manager who was handling a lot of these cases. I'm not going to mention his name now. What happened was we had probably 30 or 40 matters coming for the 4th stage of execution, and that person left, mysteriously left. Now that person also was representing 2 other banks, the exact same name, representing 2 other banks as the head of collections pursuing this matter, and the signature was different on behalf of all banks. So we had a client ring up trying to speak to this particular person and got told from the bank, that person doesn't work here, we don't know who you're talking about. So Steph actually rang and got the same response, we don't know who that is. And Steph said, well, I'm holding a document from Citibank with this person's name on it, and there's some pretty strong allegations here, I'd like to speak to them about it. They put her on hold and they came back and said, oh, he's not in yet. And this was at 11:30 in the morning. And Steph said, well, could you put me through to his PA or voicemail? I'd like to leave a message. And they said, no problem, and hung up on her. Okay, and then the following week, that person no longer worked for the company, and there was a new person in there. We write, as I said, to the CEO and the head of collections, which means we're holding them commercially liable for anything that they want to respond in return, and it's them who we will be taking to court in the future.
Is it them you're holding responsible, or their person, their
No, actually them.
entity?
And it's interesting, when they write to you, they write in upper and lower case with their name, but when they write to the client, they write in uppercase. And that's one of the questions that we ask them.
Is this process good for, did you say, mortgages and credit card debt? Is any, or
This-
just this is credit card debt?
This process is only good where money's been created out of nothing, as far as I'm concerned. It's because a lot of the questions we're asking them is, where did the money come from? See, if it came from depositors' funds, deposit means to set down. So if you deposited money in the bank, where did you authorise them to lend it out on your behalf? So where did the money come from? They've got no answer as to where the money came from other than they created it out of thin air. Okay? So this will only work where we are exposing that fraud, which is a fraud. Okay? They haven't got due consideration.
That's all financial institutions.
All financial institutions. Yeah. So only for credit cards, personal loans, car loans, mortgages, we've done the whole lot.
Store cards?
Store cards, yep.
Margin loans?
Pardon?
Margin loans?
Yeah, it's still, if they lent the money to you out of thin air, then plus there's no contract. Very rarely have we ever seen, we've never seen a contract from the other side, signed by the other side. So these are the questions that we're asking. Now, we don't want to use it where something has come back, where you've got something of substance. All right, I had one client who was a mechanic, and he wrote to me and he said, oh, Mark, I've got something to go to court now because, you know,